Well, anyways, got it going. I want to make sure I can hear myself first. Yeah, I can. Woo. Good. It works. Select my podcast, save, and then turn on monetization on YouTube. Save. Turn on monetization. Save. Got it. I know there's quite a few people that like to stay up to date with Kohberger's court case, and I am one of them. So I have already clicked on May 1st. It says that it's a memorandum. So May 1st, it shows that there was 2 memorandums and then a motion to intervene. Is this okay, this is the memorandum in support of motion to intervene. I'm going to go back to this one, the memorandum, the actual memorandum. Okay. So it says interveners are a coalition of media companies that, but for the amended non-dissemination order dated January 18, 2023, which is the gag order, would gather more information about Mr. Kohberger's arrest and prosecution and then make editorial decisions about whether and when to publish that information. The state and Mr. Kohberger, the parties stipulated of what ultimately became the gag order. And interveners were not given an opportunity to submit any written or oral objections in the approximately 1 hour between the parties submitting their stipulations and the court issuing the original gag order. Because the gag order violates interveners' rights under the U.S. and Idaho constitutions, they petitioned the Idaho Supreme Court to vacate the gag order. So they've been trying to get rid of the gag order because they're trying to say that the gag order violates interveners' rights under the U.S. and Idaho constitutions. And the Idaho Supreme Court declined to exercise its original jurisdiction because interveners have already an available remedy. The Idaho Supreme Court acknowledged that Idaho's rules of criminal procedure do not provide a specific mechanism for third parties to intervene in a criminal case, but they observed that both state and federal courts often permit the media to intervene in criminal cases on a limited basis, or at least file a motion as interested parties in the defense of public access and free speech, including in Idaho. I don't know why I said Ohio. Following the Idaho Supreme Court's direction to first seek relief before this court, interveners now move to intervene for limited purposes of contemporaneously filing their motion to vacate an amended non-dissemination order. That was on May 1st. Let's see what the second memorandum is. They said last week the Idaho Supreme Court confirmed that a vague, overboard, unduly restrictive, or not narrowly drawn gag order is an unconstitutional obstacle to interveners gathering information about this case. In petition for writ mandamus or writ of prohibition. But on procedural grounds, the Idaho Supreme Court decided that the court should have a chance in the first instance to vacate the amended non-dissemination order entered January 18th, the gag order. This is where they go into the full background. Let me go ahead and scroll up. I can read this. So, December 22nd, Bryan Kohberger was arrested and charged for allegedly murdering 4 students at University of Idaho despite great public interest in the investigation of the murders and now the prosecution of Mr. Kohberger. There have not been any notable leaks or dissemination of extrajudicial information that would prejudice Mr. Kohberger's right to a fair trial, yet the parties stipulated to a gag order prohibiting attorneys, investigators, and law memorandum in support of motion to vacate the amended non-dissemination order. Normally, they will place gag orders on cases to protect the case from any leaks, especially high-profile cases. It's a lot of family members don't like it because they want to be able to talk about the case. Maybe they got offered to pay money and the gag order is preventing anybody from trying to make money. I'm not saying the family, but, you know, even the lawyers and attorneys and everybody that's connected to the case, they'll put gag orders to prevent people from talking to the media and making money off of it. Whenever you have a lot of high-profile cases, it is known to have gag orders on the case. Enforcement personnel from making any extrajudicial statement, written or oral, concerning this case, like I just went over, other than a quotation from or reference to without comment the public records of the court in this case. The parties offered no evidence in support of their stipulations, simply asserting, as this court is aware, this case involves matters that have received a great deal of publicity. So because of the fact that this case with Bryan Kohberger has a lot of publicity, the court is trying to, and the prosecutors as well, they want to protect the case as much as possible so they won't have any leaks. Once you start having leaks out to the press of anything that's going on with the evidence to the case, that can cause a problem with the court case itself because of the fact that he could get found not guilty because of the fact that things are being leaked to the press. And even though as much as families do not like the gag order and they want to talk about the case, not only is the court trying to protect its case, but it's probably trying to protect the family as well. I would see it as, even though a lot of people don't see it as that, but it prevents anybody from trying to make a profit off the case. So if anybody's tried to contact the family, attorneys, or anything to try to make a profit off of it, then that will prevent them from doing so as well. I'm not saying that any of that happened. That's just my opinion, but people don't understand that a gag order, it protects the case itself. You know, with their prosecution, they want to be able to seal the deal of getting a prosecution on Bryan Kohberger. And if you have people leaking documents to the press that's about the case, then there goes your case. You know, they'll say, well, that was leaked out to the press, and therefore, you know, my client needs to be found not guilty. So not only are they trying to protect their case, but they're trying to protect and prevent individuals from making a current profit from the case right now, is what I feel. They said 10 days later, the court held a private meeting with the parties and an attorney for a victim's family. The parties drafted memorandum after the meeting. The memorandum is not a court order. It's the parties' memorialization of what they remember from the meeting. Even though minor redactions would satisfy any privacy concerns, the parties opted to file the entire memorandum under seal. To the public, it appealed that the meeting never occurred. So they're really trying to protect the case because they even made it seem like that this meeting never even happened to the public. 5 days after the private meeting, the court issued the gag order that is at issue in this motion. Because the preceding meeting was held privately to the public, appeared that the court issued the gag order. The court noted in the gag order that to preserve the right to fair trial, some curtailment of the dissemination of... Yeah, see, they want to make sure that they get a fair trial, that nothing is leaked out to the public. This is a high-profile case, so a lot of news organizations and journalists are going to want to get information or even speak to parties that are involved with the case to try to get articles or, on TV, and they're trying to protect the case as much as possible so they can secure a guilty verdict. And in order to do so, they feel that a gag order is needed. They said that the gag order extends beyond what the parties requested in their stipulation. The gag order applies to the attorneys for any interested party in the case. So that means that they can't leak anything out to the news, to the media. They said including the prosecuting attorney, defense attorney, and any attorneys representing a witness, victim, or victim's family, as well as the party to the above. So they are wholeheartedly trying to protect this case as much as possible to where no evidence gets leaked out to the public. In order to secure a guilty verdict, they personally feel that they need to prevent things from being leaked out to the press or to, anybody that wants to make a profit, to even someone like TMZ or anything like that. They won't be able to do so. This includes the witness, the victim's family, as well as parties to the above entitled action, including but not limited to investigators. So all the investigators can't talk, law enforcement personnel and agents. So they are really trying to protect this case and secure a guilty verdict by having this gag order. They said interveners are a coalition of media companies, but for the gag order would publish more information about the murders at the University of Idaho and Mr. Kohberger's prosecution. Exactly what I said, because you have media out there that are biting at the teeth to get any information that they can get to publish about what is going on with these murders. And it says members of the media coalition have been affected by the gag orders as follows. A victim's family wants to speak. Exactly what I just said. You have a victim's family that wants to speak to the press about Mr. Kohberger's prosecution, but they can't because they have the gag order. And I think that having the gag order, even though it's upsetting for the family, I think that it's beneficial to have, because then you don't have to worry about anything being leaked to the press or the media, and it won't affect the case at all of it being leaked out, and it will help secure prosecution's conviction. A guilty verdict is what I feel. Even though as much as it's upsetting to have a gag order, it's best to have a gag order to protect the case. No, I'm not It's probably because I have it on 18 and over. It could be why. I know there's a lot of users that are under 18. So it could be possible because I put it over, it could be possible because I put it on 18 and over. Some streams I'll put on 18 and over, and then it sometimes it will shadow ban and sometimes it won't. I noticed that more. Thanks, I appreciate it. Okay, and so Major Christopher Paris of the Pennsylvania State Police told reporter Chris Ignals that he would not answer whether police had launched any review of unsolved cases that could be linked to Mr. Kohberger because of the gag order. So they're being very stringent and strict because of the gag order that is currently in place. Moscow Mayor Art, I can't pronounce the last name, it's Bettge, told reporter Erica Zuko that the city attorney advised he could not answer questions about the overall community healing in Moscow because of the gag order. So this even prevents the mayor from even talking, which I think is a good thing. You want to protect your case as much as possible and secure a guilty verdict. A gag order is a must, even though a lot of people do not like having gag orders with high profile case as such as the Kohberger, and it's known for things to get leaked out to the press. You need to protect your case as much as possible, and having a gag order in place, I think it helps possibly try to secure a guilty verdict. It says journalist Taylor Murfin Dorisky public's records requests were denied by the county sheriff's office, Moscow Police Department, Pullman Police Department, and Washington State. Because of the gag order, if any journalist or anybody tries to request any information about the case, they won't get any information as well. It says the Moscow Police Department issued a press release that due to this order, the Moscow Police Department will no longer be communicating with the public or the media regarding this case, which I think that is a good thing. I don't think they should be talking about it at all, because there might be evidence that they may accidentally released to the public, and then the prosecutors are going to find out, and then it's going to affect their case, and then they may get a guilty verdict. It says Gary Jenkins, chief of police at Washington State University, and Matt Young, communication coordinator for the city of Pullman, told reporter Morgan Ramiro that they could not answer whether Mr. Kohberger applied for a graduate assistant research position with the Pullman Police Department because of the gag order that was in place. Moscow Police Department refused to advise a reporter from the Idaho Statesman how many cell phone towers are in the area near where the murders occurred. The size of Mr. Kohberger's cell, the size of the Moscow jail, and the nature of Mr. Kohberger's meals because of the gag order. Law and crime reporter Anjanette Levy was denied access to Kohberger's booking video from Latah County Sheriff's Office because of the gag order. Within weeks of the court issuing the gag order, interveners petitioned the Idaho Supreme Court to vacate or nullify the gag order. The Idaho Supreme Court held the interveners have sufficient standing to challenge the gag order. Let's see. The Idaho Supreme Court further noted that if the gag order is vague, overboard, unduly restrictive, or not narrowly drawn, it would be an unconstitutional obstacle to their gathering of such information. But the Idaho Supreme Court declined to vacate the gag order, opening that the proper course is first to seek redress from the magistrate court. So they have to go back to the original court, and then obviously if they get denied there, then they can take it to the Supreme Court. Following that instruction, interveners now asked the court to vacate the gag order because it's vague, overbroad, unduly restrictive, and not narrowly drawn. And the argument was justice cannot survive behind walls of silence, is what they're trying to say in their argument. For that reason, responsible press have always been regarded as the handmaiden of effective judicial administration, especially in the criminal field. And I don't honestly see that as accurate. You know, in my opinion, you can have journalists that are highly respected in their field of work, but once they get access to a court document, 9 out of 10, right now, I'm discussing about Bryan Kohberger's case. I'll do a live later this week discussing about what's going on with there's a lot that is going on with Via, and it's all very interesting as well, which I'll do a live later this week and discuss what's going on with Via. There's places that I've turned her into as well. So, like, I will discuss more about what's going on with Via on another live. Trust me, it's very interesting, the updates that I'm going to have about what's going on with Via. So they're trying to claim that justice cannot survive behind walls of silence, which that's incorrect, because you give a piece of information to even TMZ, look what they do. They go on a tangent spree and write many articles. Like, look what they're doing about Britney Spears. They even made a documentary about it. They got somebody, which everybody allegedly thinks that it's her husband, that keeps leaking to TMZ, and they keep writing out articles. And then also, speaking of it, like, you even had a high profile case with Madeleine McCann going on recently, obviously with Julia claiming that she was Madeleine McCann. You had Thea Johansson that was leaking stuff to the press, to have articles written. So having gag orders on such high profile cases, I think is needed and warranted, because of the fact that if you have no gag order, people are going to go live. They're going to be telling stories to the media. They're going to release some documents. Police officers are going to go talk to the media. Family members of the people that were killed, that were murdered, are going to go talk to the media. Friends, people that are not even involved with the case are going to go talk to the media. Media will pay anybody to get information about a high profile case. They want to be the first ones to write the article to get the exclusive. So some media outlets will pay high price to get information about a high profile case. So I think that having a gag order in place protects the integrity of the evidence of the court, and I think that it's needed. I think it's valid, even though a lot of people don't like it. I mean, I'm a journalist myself. I don't obviously like the fact that they put a gag order on it, but I see both sides, because of the fact that I know what can happen if there is no gag order on a case. So, because of the fact, I've already gone through that. So, the motion to intervene, already went through that. Motion to vacate the amended non-dissemination order. So, May 1st was when there was a notice of appearance. Come Now, Wendy J. Olson, and Corey M. Carone of Soel Rivers LLP, and enter their appearances as counsel for a coalition of media companies. So they hired an attorney. The Associated Press, Radio, Television, Digital News Association, Sinclair Media. So all these news outlets, Newsroom, DBA, Idaho Capital Sun, KTVB, and King, Seattle East Idaho News, all these news places, Lewiston Tribune, Washington State Association of Broadcasters. So all these press companies join together and have an attorney, but due to the gag order, they won't be, obviously they won't be successful. Defendant's third supplemental request for discovery. So on May 3rd, there was a third supplemental request for discovery. It says, please take notice that the undersigned, pursuant to Rule 16 of the Idaho Criminal Rules, the 4th, 5th, 6th, 8th, and 14th Amendments to the Constitution of the United States, 1, 2, 13, 17, of the Constitution of the States of Idaho request discovery and inspection of all materials discovered by defendant and aforementioned constitutional provisions, including but not limited to the following information, evidence, and materials. So they want the standard lab discovery, biological testing case file. They want them to provide a complete copy of the case file, including all records made by each laboratory in the connection with biological testing in the case, including biological screening, serological testing, presumptive testing, microscopy, and DNA testing. Please provide photographic quality copies of all the photographs in the original case file. Electronic copies of photographs are acceptable. They want the chain of custody and current disposition of evidence, which I think that is a valid request because you want to know who all has handled the evidence. They said, please provide copies of all records that document the treatment and handling of biological evidence in this case, which is just what I said, from the initial point of collection up to the current disposition. They want to make sure that it was handled with care and basically no illegal activity was taking place. They want to make sure it was properly handled. This information should include documentation that indicates where and how the materials were stored. They want to make sure how it was stored, the amount of evidence material that was consumed in testing, the amount of material that remains, and where and how the remaining evidence is stored. In the event that the chain of custody spans several different agency of laboratories, please address this request to each agency and or laboratory that handled said items. They want profiles uploaded to a DNA database. In the event that the case involves the upload of a DNA profile to either a local, state, or national database, they want to provide all the documentation maintained by the testing laboratory, including documentation maintained by combined DNA index system, which is called CODIS. Personnel within the laboratory include profiles that have been identified as unknown males. Documentation of all the uploads, including interpretation and or deconvolutions of mixed profiles, handwritten notes, spreadsheets, match, estimated results, upload forms, and CODIS search forms. For each hit, please provide match detail reports. So they're going into full detail that they want any type of information that they type to search. They want all that, including partial hits and hits that are dispositioned to be non-matching. So if anybody doesn't even match Bryan Kohberger, they want all that information. Or if they searched for somebody and they don't match, they want that information because they can present that into evidence. Say, hey, they searched for somebody else, so there's a possibility that there is another person that could have committed this crime. Any state manuals regarding the use of the SDIS and NDIS database systems. Any hits made of any profile uploaded. So if they get any hits of anybody else, they want to present that because they'll say, hey, there could be a possibility that person committed the crimes. Even if they hit on individuals, not the defendant. See, that's exactly what I was just saying. That was not the defendant and deemed to not be candidate matches, including hits to any unknown males identified via testing. Data files, they want to provide copies. They want copies of all computer data files created in the course of performing the DNA testing and analyzing the data in this case. These data files should include all sample files, project files, and matrix files, size standards files, and analysis method files. In the event that a particular data file cannot be produced, please provide name of said file with explanation for non-production. Statistical calculations, they want to be provided a copy of all the statistical calculations undertaken with regard to DNA testing in this case, including standard tests, database match, probability calculations, statistical calculations that were undertaken using software programs. So basically they want to know if they use any software and then provide them the information about the software. Biostatical calculations such as probability probabilistic genotyping programs. Please provide information for all analyses undertaken, including those that were not used or were not reported. List of software programs used, including version number, reference population, ATEL, frequency used for the analysis, all handwritten or electronic notes pertaining to the analysis, any electronic data files that were generated for imputing genetic information into a software program, all documents and electronic data files generated by the software programs, all input and operated selected parameters used for the analysis, any instructions given to the operator of the software program with regard to input and operator selected parameters to be used for the analysis. Okay, so they want to be provided communications. They said, please provide a copy of all communications between laboratory personnel and or other party with regard to biological testing in this case, including letters, memos, emails, texts, and records of telephone conversations. They want to make sure that none of this evidence, got leaked to anybody, or if they were having conversations about it besides what they were supposed to have conversations about. These materials should include communications with regard to outsourcing of DNA testing, statistical calculations of DNA profiles uploaded to a database. They want to make sure that they were talking about the evidence and not basically talking about Kohberger is what they're trying to do. Standard operating protocols and interpretation guidelines. Please provide a copy of the standard operating protocols and interpretation guidelines relied upon to perform and interpret the testing in this case, as well as all subsequent versions of these documents. Interpretation guidelines should include those that address peak detection threshold, stochastic thresholds. I had to read that again because I've never heard that word before. Interpretation of mixed samples, declaration of inclusions, exclusions, and they're just really going into full details. Policies for reporting results and statistics, and software programs used to perform biostatistical calculations as a probabilistic genotyping programs. Please include any applicable memos concerned with deviations from established procedures. I was trying to read that too fast. For any probabilistic genotyping program used, please provide standard operating procedures, include any user manuals from the provider, and any memos regarding updates to the software. They want validation summaries. Please provide a copy of validation summaries for internal validation studies undertaken to establish the interpretation guidelines relied upon in this case, including studies that address peak detection threshold, stochastic threshold, and interpretation of mixed samples. Please include validation summaries for any genotyping program used in the event of that enhanced detection method was used in the case. Provide a copy of the validation summary for said method. In the event that a software program was used to perform biostatistical calculations, in this case, please provide a copy of the validation summary for said program. So they even want the programs that were used. What? Oh, I thought you were talking to me. I thought they were talking to me. So they requested unexpected results and corrective actions. For each laboratory that performed DNA testing in this case, please provide copies of the laboratory's logs of unexpected results and corrective actions. So if they made any mistakes, they want to have the logs of that information, or if they said that the logs should be provided for the time period beginning 6 months before the start of testing and ending 6 months after the completion of testing. They want to make sure that everything was done accurately with no errors. Documentation should be provided for unexpected results that arose during mechanical, chemical, or analyst operations, including contaminations, the presence of extraneous DNA, sample handling errors, basically everything I just was going over as well, or any other reason. Logs should be provided for all laboratory personnel, not just the analysts who perform the testing. They want to make sure that there was no, yes, I am. And also, I have my own podcast that I do, which I do on the side. All reports generated by a lab that conducted CMP testing on any sample in the case, including, I have multiple things that I do. Like, I am a very multitasking person with what I do. Copies of all communications between laboratory personnel and any other persons or organizations with regard to the instant case, including letters, memos, emails, internet posts, press release, and records of other communications. With regard to any DNA profile uploaded to any public or private DNA database. All documentation associated with any database search, including but not limited to CODIS, NDIS, GED match, family tree, DNA, and or felon databases, case sample database, missing person database, and internal quality assurance database. The documentation should include, but is not limited to, the input profile, the input search parameters, the search output, all reports, all correspondence, and any follow-up actions. All documents related to any genetic genealogy search include, but not limited to, the creation of user profile, accounts, information, automated search results, uploading of data, all queries and search results from any private or public databank, family tree information, and all documents, reports, notes, or other communications pertaining to genealogy DNA database searches. All documents related to genetic genealogy investigation, included but not limited to additional collection and or testing of DNA samples, notes of interviews, documents. So if they've done any interviews, they want to have that information as well. Okay, to related to ancestry and or recommendation of further testing. All documents related to the comparison of any DNA samples collected during the genealogy investigation to crime scene evidence. They want that as well. And they want the name and address of all persons found to have sufficient sharing Morgan, with the subject profile to be identified as a match in the report created in this case. And that was signed on May 3rd. May 4th, there was a motion to compel discovery order. Let's see. It says, comes now, Bryan C. Kohberger by and through his attorney, Ann C. Taylor, public defender,
Okay, I had to go get me some water. All that talking made me thirsty. No, get down, sassy. My cat is trying to also eat my chicken tenders that I got. Anyways, let me see you drink this water real quick. I ran up the stairs, so now I'm out of breath. It says, come now, Bryan C. Kohberger by and through his attorney, Ann C. Taylor, public defender, and pursuant to Idaho criminal rule, hereby moves the court to order the state to comply with defendant's first supplemental request for discovery filed herein on or about February 3rd, 2023, and defendant's second supplemental request for discovery filed herein on or about March 24, 2023. Says Mr. Kohberger requests an order for the state to disclose the following items include in defendant's first supplementary request for discovery, request number 43. They want all the body cam and dash footage from officers involved in the search and arrest of Bryan Kohberger in Pennsylvania. As of May 4, 2023, counsel for Mr. Kohberger has not received the requested materials. Mr. Kohberger requests an order for the state to disclose the following items, including the defendant's first supplemental request for discovery. Request number 49, they want all the lab testing, including photographs and color diagrams and bench notes included but not limited to, copies of lab reports detailing the forensic evidence collection and analysis of items recovered at Bryan Kohberger's parents' home. Oh, man. Hold on a second. They want detailing the forensic evidence collection and analysis. So they want the copies of the lab reports that detailing the forensic evidence collection and analysis of items recovered at Bryan Kohberger's parents' home, trash cans, and or other receptacles. So they want all the evidence that basically they got out of the trash can, and they want Bryan Kohberger's Hyundai Elantra. As of May 4, 2023, counsel for Mr. Kohberger has not received the requested materials, and based upon information and belief, these reports contain exculpatory information. Mr. Kohberger requests an order for the state to disclose the following items include in the defendant's first supplemental request for discovery. Request number 49, all lab testing, including photographs and color diagrams and bench notes, including but not limited to ISP and FBI forensic lab reports, including but not limited to lab reports 1 and 25. Mr. Kohberger requests an order for the state to disclose the following items included in the defendant's first supplemental request for discovery. Request number 119, all notes, recordings from all officers from Moscow Police Department. As of May 4, 2023, counsel of Mr. Kohberger has not received recordings and notes from the interrogation of Mr. Kohberger by MPD Detective Payne. Number 4, Mr. Kohberger requests an order for the state to disclose the following items included in the defendant's first supplemental request for discovery. Request number 115, all police reports, audio, video evidence, and any recorded statements related to Bryan Kohberger's arrest and incarceration in Pennsylvania. As of May 4, 2023, counsel for Mr. Kohberger has not received the requested information. Number 5, Mr. Kohberger requests an order for the state to disclose the following items included in the defendant's second supplemental request for discovery. Request number 161, all reports, notes, recordings, and photos. As of May 4, 2023, the counsel for Mr. Kohberger is saying that they haven't received the requested materials on information and counsel believes these materials contain exculpatory evidence. Number 6, Mr. Kohberger requests an order for the state to disclose the following items included in the defendant's second supplementary request for discovery. Request number 160, training records of specific officers. So they want to have whenever they first became officers, they want to have the evidence of their training. As of May 4, 2023, counsel of Mr. Kohberger has not received the requested materials, so they want to make sure that those officers had the proper training to be able to handle the evidence as they did. Counsel requests that this motion to be set for hearing in order to present an oral argument, and that was dated May 4th. May 4th, they had a motion to compel discovery. Let's see. Which I just went over that. Notice remote hearing was on May 5th. So basically it's stating that you must appear using video with stable internet connection. If you're unable to do so or you require a combination, the Ottawa County Clerk's office has a public kiosk. So they were scheduling a conference on May 22nd, 2023 at 10 a.m. Judge Megan Marshall. Okay. Motion to reconsider was on May 9th. With each passing day, the amended non-dissemination order dated January 18. Okay, so basically they're just talking about the gag order again, saying that it's basically violating constitutional rights and civil rights and all the 9 yards that you want to talk about. So basically they're trying to get it to reconsider getting rid of the gag order. They think that if they keep submitting requests to the judge will eventually give in and give them what they want. May 9th, declaration of Wendy J. Olson in support of motion to reconsider. Let me see who signed this. The PDF is still coming up. Wendy J. Olson declare and states as follows: I am a partner with the law firm of Soul Rivers LLP, Council of Interveners, in the above captioned matter, as I have personal knowledge of the facts and statements obtained in this declaration. I submitted the declaration support. So they're basically still trying to request to get the gag order removed. And using the attorney to do so. And then they had, on May 11th, they had an objection to a motion, so it was ejected. They object. So comes now Bryan C. Kohberger through his attorney, Jay Wetson. So the attorney is objecting the request to reconsider the gag order. That the media's motion to vacate the amended non-dissemination order raises factual issues that Kohberger's required additional time to prepare. The media argues in its motion that it is irreparably harmed. Each day this court's amended non-dissemination order remains in place. The media argues that this court should grant temporary injunction against its own injunction. It claims that this was an intent of the Supreme Court because it moved quickly to determine that its petition for a writ was filed in the wrong form and using the wrong vehicle. What the media fails to know is that the Supreme Court provided no such directive in its written decision. It also fails to note that the petition for a writ was a purely legal issue, whereas it was repeatedly argued the basis for entry or amendment of a non-dissemination order is a question of law. The media seems to be acting on the premise that the order should simply vanish now that it has arrived on the scene. Instead, the court has reasonably and correctly recognized the proper path forward is a hearing where the parties may show that the evidence there is of prejudice and the potential for prejudice to Mr. Kohberger's 6th and 14th Amendment rights to a fair trial. So they're just basically trying to protect the integrity of the court to where none of their evidence is leaked out to the press with the gag order. State's response on May 12th comes now the state of Ohio. Why do I keep wanting to say Ohio? I don't know, but Idaho. It's like I don't know why I have the word Ohio in my head. By and through the Latah County prosecuting attorney and submits the following response to the motion to compel discovery filed by the defendant on May 4th. By way of background, as of the date of this response, the state has provided the following discovery to the defendant: approximately 10,000 pages of reports and other written materials, approximately 10,200 photographs, approximately 9,200 tips. They've had a lot of tips. Approximately 50. So they have 51 terabytes of audio, video, media, and digital materials. So I was way off. The state has disclosed all items it is aware of relating to the search and arrest of Bryan Kohberger in Pennsylvania. The state is unaware of any body cam and dash cam footage beyond what was disclosed. Numerous lab reports regarding forensic evidence collection and analysis of items recovered from the defendant's parents' home, trash can. This is basically giving them all the evidence that they were, requested. FBI laboratory, Virginia, as well as the Idaho State Police lab. The defendant's attorneys and investigators have also been direct access to view and inspect items that were seized at the parents' residence and the vehicle. Let's see. Order denying motion to reconsider in... This matters before the Court of the Associated Press. After due consideration and for reasons set forth herein, the motion to reconsider is denied. So they deny the request. Factual and procedural history. November 13, 2022, 4 University of Idaho students were found deceased in their home in Moscow, Idaho. The tragedy garnered widespread publicity and worldwide attention. So because of the fact that it's got worldwide attention, while authorities were investigating the incident, media outlets transited upon the vandal community, and the internet and television were abuzz with stories and immense speculation. So they're just basically trying to protect the integrity of the court in the case and the evidence to where the media don't get access to it. May 16th, they released the indictment. Bryan C. Kohberger is accused by the grand jury of Latah County by this indictment of the crimes of burglary, Idaho Code, a felony in count 1, murder in the first degree, Idaho, a felony in count 2, murder in the first degree in Idaho Code, a felony in count 3, murder in the first degree in felony count 4, and murder in the first degree in felony count 5. I thought they. Oh yeah, the burglary was count 1. I was like, wait, I thought they got him for burglary too. So notice of hearing was sent out on May 16th. That's just letting everybody know about when the court hearing is. And then May 16 order governing courthouse and courtroom conduct. So they gave an order. This order governs courthouse and courtroom conduct and media activities in this case. It's basically saying what the media can and can't do in the courthouse and the conduct of the people that are in court. They need to be mindful of the need of balance, constitutional right of the defendant to a fair hearing, basically letting him know that, hey, he's not found guilty, so he still needs to have a fair hearing. They want to, they ordered courtroom seating and attendance, seating for victims, family, counsel, defendant's family, and court personnel. Certain seatings may be reserved for counsel, authorized court personnel, the defendant's family, and the victim's family. Pooled media seating. They selected, I guess, individuals from the media. The representatives of the media serving as the pooled camera staff. Yeah, so they pulled some camera staff shall be seated in the area. General public and additional media seating. Seating in front of the bar. Entry and exit during court proceedings. General restrictions and requirements. Security screening. All person entering the courtroom are subject to security screening. No food, beverage, firearms, or other weapons. Cell phones. Cell phones are permitted, but they must be turned off and shall not be used for recording. Other electronic devices, computer, laptops, and other similar devices are permitted for note taking, but shall not be used to record, transmit sounds or images in or from the courtroom. Cameras and microphones and electronic devices must be disabled. Disruptive behavior. Any activity or behavior which is considered disruptive by the court will result in removal. Media coverage. In the court allows cameras in the courtroom and orders that the media coverage be pooled. Then all mediums shall have access to and share the video, audio, and still photographs received from the permitted cameras. Members of the media shall designate and agree on the operator of each camera permitted. Courtroom media requirements. Allowed media representatives and their equipment will be located in the area of the courtroom designated by the administration district judge. Portion of proceeding which may be televised. Restrictions on video and photographs, interviews, reporting, and vehicle parking, media inquiries, security, disruptive behavior. Anything that they consider to be disruptive, they'll remove you from the court. They had a motion to seal the grand jury witness, order to seal grand jury witnesses on May 17th. Order regarding notice of hearing Zoom information, which is on May 19th. May 19th, Second Amendment notice of hearing. May 19th, Second Amendment notice of hearing. May 19th, Second Amendment order vacating hearing. May 19th, motion requesting release of grand jury materials under qualified protective order. May 19th, motion to enlarge time to file pretrial motion. May 19th, motion to make available the record of all proceedings of the grand jury. May 19th, order to enlarge time to file pretrial motions. 522 is the court minutes. May 22nd was the custody order. May 23rd is the court minutes. May 23rd, notice of hearing, which is a July trial, which I'll go over that. This is on May 23rd. All the smaller stuff I won't really go over because of the fact it's like not really important to the case. If it's something that's important to the case, then I'll talk about it. Like I'll pull it up and let's see. Okay, here we go. So they sent out a notice for a jury trial, which is October 2nd, 2023 to 11/12/2023, and the time starts at 8:30 a.m. So that is when the trial is. Notice of hearing, Mr. Gray's motion. Let's see what that's about. In the District Court of the 2nd Judicial District of the State of Idaho and in and around the county. Motion hearing, Mr. Gray's motion. Notice of hearing, motion to compel. Notice of hearing, Mr. Crone's motion. Order setting briefing schedule and scheduling oral argument was on May 23rd. State's request for discovery disclosure was on May 23rd. May 26th, state's response to defendant's motion. May 30th, state's response to defendant's motion regarding grand jury record and transcript. They wanted to have an order to seal AT&T, Google, Reddit, Snap, Strava, TikTok, declaration of Alex Brzee in support of motion, declaration of Angela Levy in support of motion, declaration of Chris Ignals in support of motion, declaration of Erica Zuko in motion, support of motion, declaration of Morgan Romero in support of motion, declaration of Sally Cruz. So this is all of his attorneys filing a declaration of support of motion. Okay, let me go down. Supplemental memorandum in support of motion to vacate the amended non-dissemination order was filed June 2nd. So June 2nd, supplemental memorandum on cameras access in courtroom. I don't know if this was Court TV's request. I know Court TV got denied a media request. Recognizing the benefits to the community and integrity of the justice system, Idaho is more open to media coverage of trials than other states. It allows audio-visual coverage. Argument, the community members throughout the University of Idaho. I don't know why I keep saying Ohio. I mean, Idaho. Why is my brain like fixed on Ohio? The community's interest in the case, as reflected in the First Amendment, favors allowing camera access. So this was all filed on June 2nd. Supplemental memorandum on camera access in the courtroom. Notice of hearing defendant's motion requesting release of grand jury materials. On June 5th, notice of hearing defendant's motion to make available records of all proceedings of grand jury. June 6th, state's supplemental response to defendant's motion. June 6th, defendant's memorandum on cameras during hearings. Defendant's motion for order permitting Zoom participation. Defendant's motion to shorten time. Let me see what they mean to shorten time. Comes now, Bryan C. Kohberger, by through his attorneys, Ann C. Taylor, public defender, and hereby moves the court for an ordering shortening time for hearing the defendant's motion. Okay, motion to take judicial notice of press coverage and defendant's motion. So they're basically just trying to limit the discussion about allowing the press in the court. June 6th, objection to media's motion to vacate the amended non-dissemination order. So they're still obviously talking about the gag order, trying to get rid of it. Response states response to motion appeal, amend and or clarify. June 6th, response to Associated Press motion to intervene. June 6th, state's brief on video photographic coverage. And then June 6th, stipulation for protective order. I'm going to read about the stipulation for the protective order. Come now, the above named parties by and through their undersigned attorneys and hereby stipulation to the entry of a protective order pursuant of Idaho criminal rule as follows. This protective order pertains to records obtained by from the University of Idaho during the course of investigation. In this case, these records fall into two categories: records pertaining to Madison Mogan, Kaylee Concalves, Ethan Chapin, and Xana Kernodle. Records from the University of Idaho pertaining to other individuals, including students, faculty, and staff, and records from the University of Idaho's Office of Civil Rights Investigation. By way of background, the records of the University of Idaho are protected by various federal and state laws, including the Family Education Right and Privacy Act, as well as various state personal information privacy protections. The state has been advised by legal counsel for the University of Idaho that FERPA protections do not survive the death of the subject individual. Consequently, the FERPA issues in this case do not apply to University of Idaho records regarding the 4 individuals that were murdered. However, other personal privacy protections remain, including protected information is defined in Idaho criminal rule. The state will redact the information in accordance with Idaho criminal rule. Response to Associated Press motion to intervene. June 6 states a brief on video photograph coverage. June 6 stipulation for protective order, which I just went over. Notice of hearing, which was sent out June 7th. Let's see when the hearing is. Notice is hereby given that Bryan C. Kohberger, by and through their attorney, and C. Taylor, public defender, and will call on for a hearing defendant's motion to take judicial notice of press coverage and defendant's motion for order permitting Zoom participation at hearing for witness or to continue hearing in the above entitled matter. June 9th at 1:30 p.m., which was just yesterday. They had a Zoom hearing yesterday. June 8th, order permitting remote participation at hearing. June 8th, order regarding notice of hearing. Okay, let's see. State's motion to temporary seal. What are they trying to temporary seal? Let's see. The state of Idaho, by and through the Latah County prosecuting attorney, respectively moves the court pursuant to Idaho Court Administrative Rule and Idaho Code 74-124 for a temporary order sealing the exhibits A and B attached to the state's supplemental response to defendant's first, second, and third supplemental request for discovery herein, because release or disclosure would interfere with the enforcement proceeding, deprive a person of a right to a fair trial, constitute an unwarranted invasion of personal privacy, disclose the identity of a confidential source, disclose investigation techniques and procedures. The state seeks this protection pending a hearing on the matter. Wherefore, the state respectfully prays that the court seal. So they're basically wanting to seal everything. And then state supplemental response. Okay, a temporary order sealing, let's see, on June 8th, and then defendant's response, and then June 9th, motion for an exception or in the alternative to extend time. So based upon the motion to temporary seal exhibits A and B of the state's supplemental response to defendant's first, second, and third supplemental request for discovery filed herein, the court does not hereby confirm in order that exhibits A and B are confidential, exempt from disclosure, and are sealed pursuant to Idaho courts. So for reasons stated in the motion and until a hearing can be held on the matter. So basically they sealed it until a hearing was held. June 9th, defendant's response. And then we'll get to the very last one, which was yesterday. So it'll be about a 2-hour live, which is what I predicted. Comes now Bryan C. Kohberger by and through his attorney of record, Ann C. Taylor, public defender, and hereby submits the defendant's response to the state's request for discovery, disclosure, and alibi demand filed. So they basically want an alibi, and they want it received, filed with the court on May 23rd, 2023. They demand an alibi. All books, papers, documents, photographs, tangible objects, or copies or portions thereof, which are within the possession, custody, or control of the defendant, and which the defendant intends to introduce in evidence at trial. Mr. Kohberger's investigation and preparation of his defense is underway, as determinations are made by trial evidence. The same will be timely disclosed. All results or reports or physical or mental examinations and or scientific tests or experiments made in connection with this case or copies thereof within the possession or control of the defendant, which the defendant intends to introduce in evidence at trial, or which were prepared by a witness whom the defendant intends to call at trial when the results or reports related to testimony of the witness. Mr. Kohberger's investigation and preparation of his defense is underway, as determinations are made about the trial evidence. The same will be timely disclosed, as determinations are made about testifying witness relating discoverable materials will be disclosed. A list of all the names and addresses of all witnesses the defendant intends to call at trial. Mr. Kohberger's investigation and preparation of his defense is underway. Trial witnesses will be disclosed and determinations are made. Mr. Kohberger does intend to call individuals named in the state supply discovery materials. And number 4, written summaries or reports of any testimony the defense intends to introduce pursuant to rules 702, 703, or 705 of the Idaho Rules of Evidence at Trial or Hearing. The summaries provided must describe the witness opinions, facts, and data for those opinions, and the witness qualification, disclosure, or expert opinions regarding mental health shall also comply with requirements. Mr. Kohberger's investigation and preparation of his defense is underway. Once determinations are made and materials are prepared, Mr. Kohberger will supply information consistent with Idaho Criminal Rules 16 and Idaho Rules of Evidence 702, 703, and or 705. Further, if Idaho Code 18-207 is applicable, Mr. Kohberger shall comply with requirements thereof. Mr. Kohberger has filed a contemporaneous motion for an exception, or in the alternative, an extension of time for notice of alibi. So basically, they want an alibi for Bryan Kohberger. They want to know where he was at the time of the deaths occurred, or the murders, I should say. So that is everything, and I have everybody up to date now. I did not get to go over May's. I know I went over April's, and now I went over May's and June's. So I'm going to go ahead and end this stream, and I want to thank everybody that's watched it. I did make it to where 18 and over can watch the stream on TikTok. So and on YouTube, obviously, that's automatically set. It's not for anybody underage. But I'm going to go ahead and end my stream, and I want to thank everybody that, it would be nice if I spelled Bryan Kohberger's name right. There we go. Had to fix that. whenever the trial occurs, I will go live and I will discuss the trial. I was really hoping that Court TV or another news media would be able to air the trial so then I could, show it and then we can discuss while it's live. So we'll have to wait and see what happens. But I am going to go ahead and end my stream because of the fact that now I have gone through all the court documents for the last 2 months. So I hope everybody has a good day.